June was a big month for immigration in the United States. The Trump administration continued to try to end immigration to the US. I'm also going to talk about what you need to be aware of for July.
Calificas para ser legal, quieres saber, solo llama al abogado Andrés Mejer.
So let's jump right into it. What happened in June in immigration in the US? Supreme Court said that DHS and President Trump could not end DACA the way they went about it. Here's what you need to know. 1. They can end it. 2. It has to be ended in a specific way. 3. Several people in the administration have said they expect a 6-month phase out of DACA. That means if you qualify, apply now. Don't wait or you're going to miss the opportunity. Here's what you need to do. Obviously, if you're eligible, you got to apply. Second, we have a report with the 7 eligibility requirements for DACA. If you want it, just type in DACA, D-A-C-A, in the comments below, and we'll send it to you. You can also review our previous video on the subject. The link is below. See if you can apply for advance parole. If you have DACA and you don't have legal entry in the United States, applying for advance parole will get you permission to leave the US and then come back inside in the US, giving you legal entry, which can assist you in getting your green card in the future. If you want more details about what that program is, take a look at the link below. Just last week, I talked about in detail DACA and advance parole. So learn more about advance parole, just click below. Fees are going up for DACA, almost double. So don't put off applying for this. If you qualify, do it now. If you're not sure if you qualify, well, find out. Get that process started as soon as possible. Moving on. I told you this administration was going to do everything it could to stop legal immigration. Well, here's another example of them trying to do so. On June 20th, 2020, Trump announced a proclamation extending the stopping of work visas that he initially made on April 22nd, 2020 for the rest of the year. This means no visas will be issued for the following categories. 1. H-1B visa and their dependents. These are typically college graduates, the majority of which studied inside the United States and now are looking to use their education to help and to work inside the US. H-2B visas and their dependents. They're very common in landscaping, restaurants, hotels, during busy seasons, typically touristy areas. Now, they're also used in agriculture, but that is exempted, and we'll talk about that shortly. J visa, that's number 3. For example, interns, trainees, camp counselors, au pairs, or summer work travel program plus their dependents. And L visa, that's number 4, which is intra-company transferees from outside the United States to the US and their dependents. So we're talking about a company that has multiple offices, some in the US, some outside the US, and is moving a high-level employee from outside the US to the US, maybe for a year, maybe for 2 years, before, it usually starts off temporary. It may be directly for their green card in the future, but somebody who has education or likely experience at a very high level, and the company needs their services inside the US rather than outside the US. This proclamation only applies, first of all, if you're outside of the US from April 22nd, 20, this is when it was initially announced, and extended now for the rest of the year. So you have to, if you're inside the US, this doesn't apply for you. If you presently have any of these visas, like a J1, an H1B, an H2B, an L visa, if you're in the US and you presently have it, you're fine. You can't apply for a new visa, but if you have a visa already, the fact you're outside the United States won't stop you from being able to re-enter. So let's say you had an H1B visa, you went to visit your family in, end of February, beginning of March, and you got stuck because of COVID-19. Now, you had the visa, you just couldn't get on a plane to come back. So you're not applying for a new visa, you still have one, and for that reason, this proclamation doesn't apply for you. Now, the proclamation doesn't even prevent your re-entry with a valid travel document like advance parole, as long as it was issued to you before April 22nd, 2020. Point is, you can't apply for a new visa, but if you have it, you're okay. Now, if you need to renew it, chances are you're going to have a problem if it's about to expire during this period. The following individuals are completely exempt from this proclamation. Obviously, U.S. citizens, right? Also, green card holders, lawful permanent residents, spouses or children of a U.S. citizen, exempt. Foreigners seeking to enter the U.S. to work on the U.S. food supply chain. For example, farm workers coming to the U.S. on an H-2B visa. Happens very much in the South and in agricultural states. Also, there's a big category for anyone DHS determines would be in our national interest to enter. What does that mean? Let me tell you. So the first criteria is, or the first group is critical to the defense, law enforcement, diplomacy, or national security of the United States. Second, someone who provides medical care to COVID-19 patients, or related to that, someone involved in medical research at U.S. facilities for COVID-19 work. Necessary for economic recovery. We have no idea what that means. It's a very broad area. I could think of, well, there's a variety of scenarios where that could apply, and we'll see if it helps any of our clients. Now, children who would age out for a visa, meaning they are dependent on their parents, and in other words, they are minors, they are under 21, but during this period, they become over 21. When they age out, they no longer qualify for certain benefits so for example, let's say an employer filed for me, and my daughter is 19, but it's taken so long, I've now been approved, but we can't come into the United States because let's say we can't board a plane, and my daughter's about to turn 21. She would age out under that application, but for this exemption. What do you need to know for July? Fees are going up. That is the number one thing. Now, don't confuse this with the 10% increase that the USCIS asked Congress to put in place. That is a separate increase. USCIS, or Immigration, United States Citizen Immigration Services, said if Congress does not bail them out, they are going to furlough employees. Now, if they do get the bailout, the 10% increase in fees is to pay back that amount. So, here's what's changing. Office of Management and Budget received these suggested price increases 2 weeks ago. Now, they haven't signed off on it, which means that they may be the actual fee will change in the coming weeks, but here's what we know. Naturalization applications, N400, is presently $640 plus biometric, which is $85. It's going up to $1,170. That is an 83% increase, almost double. Third, adjustment of status, that is Form I-485. That could be from a U visa scenario, it could be from a family-based petition, it could be from asylum, it could be for special needs juvenile, it could be for VAWA, it could be for cancellation removal. Doesn't matter. The I-485, for whatever reason, currently it's $1,225. It's going to go up to $2,195 per person. Now, work authorization and travel is included in that. It's going to be separate. That means fees are going to go up even higher. Asylum applications today are free. They're going to go up to $50. Now, if this gets approved, mark my words, it's going to go way up in the future. They're doing it $50 to make it seem like it's a nominal amount. Oh, it's not a big deal. Why can't they pay $50? The moment that they change the law to from humanitarian relief is free to there is a fee, the fee will go up. I guarantee it. DACA renewal goes from $495 to $765, about a 50% increase. They want to get rid of fee waivers for citizenship applications, that's the N400. Adjustment of status, that's the I-485. To replace or renew your green card, the I-90. And employment authorizations, I-765. Now, it does not apply for VAWA, it does not apply for TPS, but almost every petition you can think of has the ability for a fee waiver. The government wants to get rid of it completely for overwhelming majority. Now, clarification. With all the changes that have happened this month, there have been many news stories. Reporters do the best that they can, but sometimes they don't use terms correctly. Immigration is complicated. There was a news story where the reporter kept saying that DACA recipients would keep their work visas, and this is just flat out incorrect. DACA recipients and mostly everyone applying for legal status gets work authorization, aka EAD, Employment Authorization Document. The EAD does not give you legal status or authorization to stay in the United States. It only says that it gives you the permission to work for a finite period of time. In almost every scenario, you're not applying for work authorization, you're not even applying for a work visa. You're applying for some kind of status or some kind of visa that either while it's pending, you get work authorization, or when it's approved, you get work authorization. For example, DACA. DACA is not a work visa, it's just protection from deportation, and you only get work authorization after it's approved. Now, a work visa is temporary, and usually the person who has it is considered to have non-immigrant intent, meaning they're coming here for a defined period of time, a year, 2 years, whatever that is, for a specific reason. And it doesn't typically allow them to apply for a green card. Most non-immigrant visas are not what's called dual intent visas. Meaning, if I want to come here as a tourist, that doesn't mean I can also or intend to apply for a green card for law to adjust my status. Now, a student visa does allow for that because a student visa is a dual intent visa. But DACA is not a work visa. DACA is not even legal status. So I'm not going to name names, but that reporter got it fundamentally incorrectly. Let's talk about Supreme Court's recent decision about asylum seekers that most are calling a win for the government. A farmer from Sri Lanka, his name is Vijayakumar Thurasijam. I'm sorry if I butchered your name, I do the best I can. He was picked up by Customs Border Patrol and he claimed asylum, saying he was picked up and beaten by unknown men in his country because he was a member of the Tamil minority. His asylum claim was denied, saying he did not establish a credible fear. Now, put it in context, for an asylum application, you need to show that you're afraid to go back to your country because bad things happen to you, or you have a strong suspicion bad things will happen. Secondly, you're afraid of the government or a group the government can't control. And three, you're afraid of for a protected reason: race, nationality, ethnicity, political opinion, particular social group. So he said, listen, hey, I'm a minority. I'm an ethnic minority. I was abused by the government and gangs that the government can't control. And I'm afraid to go back because look at the bad things that happened to me. I don't know what happened, but on its face, he meets all of the elements. Now, the officer said he wasn't credible. So he gave him an expedited order of removal. That means he's gone. So in a credible fear determination, if you're not found credible by an officer, you're then getting an order of removal and you're gone in a very short period of time, unless there's a means to stop it. So the ACLU sued on his behalf. He said, listen, his due process was violated, meaning he was not given notice and an opportunity to be heard under the law by just getting an officer's decision. Due process in the plaintiff's position has to be a court of law. The Ninth Circuit Court of Appeals agreed and said his detention is subject to the review under the suspension clause of the Constitution. That's what gives people rights when they are detained by the government. The Supreme Court, in a 7-2 opinion, that's an overwhelming majority of the Supreme Court justices, the majority opinion was written by Alito, said that, listen, asylum seekers only have the rights given to them by Congress. In this case, Congress decided his case is only to be heard by an immigration official. The court can't give him rights that Congress took away. In other words, this is a political issue. This isn't a judicial issue. Whether it's correct or not, whether it's appropriate or not, whether they would prefer to do something different or not. Congress made a decision. That decision is appropriate, and the court can't do anything about it. That's a very big deal, because this administration wants to replace asylum officers with Customs Border Patrol officers. So you're going to have people with very little experience, very little education and training, making decisions on whether someone is credible or not. That's a recipe for disaster, particularly when it's not reviewable. So you have people that don't know what they're doing, making whatever decisions that they want, and Customs and Border Patrol does not have a good track record. You know, there's been a lot of bias, there's been a lot of lawsuits against them, they've done a lot of things wrong over the past couple of years. These are not the people that you want to trust to make a fair and open-minded decision when your life is on the line, because you don't know who you're going to get. Immigration, particularly USCIS, has notified its staff that they will be furloughed. It was supposed to start July 20th, but now it has been changed to August 3rd. What does that mean? It means they're going to get laid off. Now, filing fees from new applications has gone down over 50%. Just think about it. Past 3 months, nobody's really been filing new applications. They said they're going to have to lay off 13,000 people. So imagine how long it's going to take you to get your green card if 13,000 officers, trained, experienced, are going to be laid off. Do you think that this is any surprise? This shouldn't surprise you. This administration will do anything they can to stop legal and illegal immigration. But make no mistake, they are not stopping at illegal immigration. They've already stopped that. All of the recent changes, they're using COVID-19 as a pretext in order to stop legal immigration. So filing fees are going up. The wait times are going to go up dramatically. You should not wait. You need to file right away. You need to get your case in line, because right now there aren't a lot of applications. Filing fees have not yet gone up, and the employees are still there. Let them decide your case. File as quickly as possible. Don't wait until the filing fees go up and the wait times skyrocket. You need to file, and you need to file now. Thank you for tuning in for this update for July. What happened in June and what to expect in July. I'm Mejer, immigration attorney, public speaker, and published author. If you have any questions, please put them below. I will try to get to them as soon as I can. If you know of anybody that this video would be helpful for, please share it. Subscribe to our channel. Come back and listen again. We're here every week. Thank you.